Specialists.
Yeah. Yes, call the list.
One.
I appeal for the applicant to list.
Yes, it is sorry.
Kindly have a look to Lush's last order.
Who is for the alleged complainant?
Not appearing. They have not yet served us the calculation also. Lush specifically directed the calculations be served 3 days prior to.
Very good. Let me keep it password for some time.
I'll inform Mr. Jha. Lush has passed it over. Other side. Inform him.
Then ask him to come at 11 o'clock.
I'll give him a call.
Or in the event both sides are available, then sir, I shall take up the matter. Yes.
I will show you lordship the provisions of
Yes.
the circular.
Yes, madam.
My lord, kindly come to rate circular number 74 of 2005. That is at page 17 of my opposition.
Page 17.
17. R1. My lord, this
Yes.
is rate circular number 74 of 2005.
Yes.
My lord, kindly see clause number 2. Clause number 2 is in respect of free time for loading and unloading of wagons. Free time for loading and unloading of different types of wagons and allowances, if any, at wood sheds and sidings, even old steel plants and all other steel plants are prescribed in paras 2.2, 2.3 and 2.4 respectively. Now, my lord, kindly come to next page, para 2.2. Next page, page 82.2. Free time for loading / unloading of wagons at goods sheds and sidings. My lord, there are different types of wagons. In this case, my lord, it is covered wagon. That is item number 4. Covered wagons like BCN, BCNA, BCNHS, BCNHS, BCX, BCXA. My lord, and kindly see the last unloading. Last stated unloading. The time is 9 hours. It is an additional position.
26 wagons and above.
In this case, there are 46 wagons.
Yes.
No matter 45 wagons. As such, this is applicable. The free time is 9 hours.
Yes.
Now, can we come to page 21? Page 21.
Yes.
Clause 3, that is rates of demurrage charge. Clause 3, rates of demurrage charge. Well, this circular has been modified in respect of rates of demurrage charge by corrigendum. The corrigendum is at page 45 of my opposition.
Yes.
No, my lord, I am wrong. This is at page. No, no, page 24.
Page 24,
Yes, my lord.
not 45.
Huh.
After page number 21,
Huh.
I look to
This
421.
clause, only this clause. Rates of demurrage charge. Now, kindly come to page 24. That is corrigendum to rate circular number 7. Corrigendum to rate circular number 74 of 2005.
Revision in the rates of demurrage charges.
Yes, my lord. Well, kindly see 3.1. Demurrage charge shall be levied at the rate of 100 per 8-wheeled wagon per hour or part of an hour for detention of wagon in excess of the permissible free time for loading and unloading. Well, in this case, it has been calculated by taking ₹100. There is no dispute in this regard. Now, my lord, again come to page 22.
Yes.
Well, kindly see clause 3.4 at the top. The rates of demurrage charges specified above shall be applicable equally to all types of 8-wheel goods wagons and coaching vehicles, irrespective of their carrying capacity. Next is, my lord, clause 4, that is permissible free time for removal of goods from railway premises.
Yes.
4.1, permissible free time for removal of goods from railway premises at present are as under. Number 1, goods available for delivery after unloading on the day of unloading 12 hours, and goods after unloading available for delivery on the following day, that is also 12 hours. Well, this clause has also, particularly the free time, this has been modified by a letter that is at page 45. Modified, not clarified, my lord. Clarified by letter dated 17th March 2010. That is at page 45.
Permissible free time for removal of goods from railway premises.
Yes, madam.
That is what charges?
Not charges, the time.
Yes. So after unloading. After unloading from wagon.
Yes, madam.
Page 45.
45. Page 45, part 10.
Yes.
Where I am placing this later. Subject, my lord, kindly see commercial placement of a rake for levying demurrage and or warfare charge. A clarification has been sought as regards reckoning of free time for a rake which has been placed on a line where free space is not available on adjoining platform due to non-removal of consignment unloaded from other rake. Well, in this case, their case is that the line was not clear, other rake was there in the line.
Clarification has been sought as regards recording of free time for a rake which has been placed on a line where free space is not available on adjoining platform due to non-removal of the consignment unloaded from other day.
Yes, ma'am.
It is their case.
Yes, ma'am. Next paragraph, my lord. The matter has been examined, and it is to clarify that commercial placement of a rake will commence from the time of its operational placement in the railway goods shed / siding, irrespective of the fact that unloading / loading could not commence immediately for reasons such as non-availability of free space on adjoining platform, non-availability of cover shed / rain, etc., provided that such time of operational placement lies within the working hour of that particular railway goods shed / siding. In case of time of operational placement is beyond the notified working hour of the railway goods shed / siding, the rake will be treated to have been commercially placed from the onset of next working hour. Well, irrespective of the fact whether the platform is occupied by some other rake or not, it has to be calculated as follows. So there is an illustration.
Give me a second. The time of the operation irrespective of the fact that unloading irrespective comments immediately contact the site. Yes.
My lord, usually the working hour in a goods shed is from 6 to 10. It starts at 6 a.m. in the morning and it is up to 10 p.m.
Yes.
Say working, that is why my lord illustration has been given. Say working hour of a goods shed is 6 to 22 hours. That is 6 a.m. to 10 p.m.
Yes.
Now, if a rake is placed at 7 hours means 7 a.m., my lord,
Yes.
in the goods shed, its commercial placement will commence at 7 hours, as 7 hours lies between 6 to 22.
Yes.
If a rake is operationally placed at 23 hours, means 11 p.m. in the night, its commercial placement will commence at 6 hours on the next day. It will commence on at 6 p.m. next day. As my lord, 10 to 6 is closed. The goods shed is closed at that point of time. Similarly, if a rake is operationally placed at 5 hours, its commercial placement will commence from 6 hours of the same day. The reason for non-commencement of loading / unloading from the rake immediately after its commercial placement for reasons like non-availability of raft due to occupancy by consignment unloaded from earlier rakes, etc., would be considered at the time of granting waiver. So whether it is blocked or not, it will only be considered at the time of waiver, not at the time of calculation of the damage or worthless charges. The application of waiver, if prescribed by the rail user, will be forwarded by the concerned station manager / chief goods supervisor to the divisional officer, giving full details of the factual position as prescribed under rules of waiver by para 2.5 of rate circular number 39 of 2004.
That they are paid. That they are paid.
Yeah,
Subsequently, they are paid for waiver.
My lord, as such, when it was calculated, we have calculated on the basis of this circular. My lord, in this case, they have placed the rake at 5:5 p.m. in the evening on 5th March 2010.
At
5:5 p.m. On 5th March 2010.
5th March 2010.
And it was
at
5:5.
5.05
05
hours.
5:5 p.m. 17.05 hours. That is 5.5.
17.05
hours.
Yes.
And the rake was released on 6 March 2010 at 8:40 p.m. my lord, so on 6 March 2010, unloading was completed at 8:40 p.m.
That is at 20,
20:40.
20-40 hours.
20:40 hours. That is, my lord, 8:40 p.m. Unloading was completed.
Hmm.
My lord, they have unloaded the wagons and they have placed the goods in the railway premises. From railway premises, they have to remove the goods. That they have completed on 8th March 2010 at 8 p.m.
Removal
from the railway platform premises. On 8th March 2010 at 8 p.m. Now, there is no dispute in regard of these timings.
at
8 p.m. and 20 hours.
20 hours.
20 hours.
Yes.
Now, my lord,
So far this is concerned, these are not disputed.
no. Now, my lord, kindly come to again page 22.
Yes.
My lord, clause 5 is in respect of rates of workplace charges. And for 5.2 is rates of workplace charges prescribed above shall be uniformly applicable to all commodities. Now, my lord, I am showing your lordship the next circular. That is circular number 84 of 2006. That is page 24 of my opposition. That is the circular in respect of waiver. Page 24 of my opposition.
Yes.
Page no, page 31. Sorry, my lord. Page 31 of my opposition.
No, 24.
No, 31.
Yes.
This is rate circular number 39 of 2004. Well, kindly see the heading: rules regarding waiver of demurrage and or workplace charges.
Hmm.
Well, clause 1 is in respect of power of officers who can waive demurrage or workplace charges. Well, kindly come to 2, waiver. I am placing this clause, madam. 2.1. Due care should be taken in preparation of the demurrage/workplace bills at the first instance to obviate recasting of bills subsequently on representation by the customer or otherwise. In case the consignor/consignee feels that the demurrage/workplace was due to reasons beyond his control, he could apply for waiver, giving all relevant details with documentary evidence wherever necessary. Kindly come to next page. Clause 2.3. First application for waiver of demurrage or workplace should be submitted to the station manager/goods supervisor within 10 days from the date within 10 days from the date up to which these charges had accrued. Next is 2.4. In case of workplace, the consignor/consignee should first remove the consignment from the railway premises, deposit the amount of workplace charges, and submit the original proof of such payment along with his application while preparing for waiver at first. There is no dispute in that. Next clause is important, madam. Clause 2.5. The concerned station manager/chief goods supervisor will forward the application for waiver of demurrage or workplace to the divisional officer together with the factual position and remarks within 3 days of receipt of the application. So, my lord, the report of the chief goods supervisor or station manager is the most important. On the basis of their report only, it will be waived. And I am again reading this clause. The concerned station manager/chief goods supervisor will forward the application of waiver of demurrage or workplace to the divisional officer together with the factual position and remarks within 3 days of receipt of the application. My The officer did not know the facts. The facts will be
Provided by the
yes, madam.
person in the who are
Yes.
working in the ground level.
Yes, madam. Next clause is important, is clause 2.8. In circumstances which lead to accrual of damage / warfare charges can be broadly grouped in 3 categories as under. Number 1, reasons within the control of consignor / consignee. Number 2, reasons beyond the control of the consignor / consignee like labor strike, transportation strike, general burns, agitations, riots, curfew, fire, explosion, heavy rains, or other abnormal / unforeseen circumstances. Number 3 is act of God, act of war, and act of public enemy. So, my lord, in this case, it comes under 1.
One category.
Reasons within the control of the consignor / consignee.
Yes.
Next clause is clause 2.9. In case of category 1, that is in the instant case,
This
waiver.
is within the control of consignor or consignee.
Yes, madam. In case of category 1, waiver should normally be not done. However, if at all waiver is to be granted on justified and meritorious facts, speaking order should be recorded in all such cases. So, my lord, waiver is not, it is not mandatory that they will apply and we will give waiver. It is our discretion whether we will give waiver or not, depending upon the facts of the case. As regards case pertaining to category 2 or 3, waiver can be considered on merits of individual case. 2.10, my lord. The powers for waiver as mentioned above should be exercised judiciously, keeping in view the merits of each case as per instruction contained in this letter. The waiver should not be granted in a routine manner. 2.11. Whenever the waiver exceeds 50% of the power conferred on an officer, reasons of such waiver should be recorded in writing. Next is, my lord, clause number 3, appeal against orders of waiver.
Yes.
A consignor / consignee can prefer an appeal to a higher authority in case he is not satisfied with the decision of the lower authority. The station manager / chief goods superintendent should forward the appeal to the divisional authority within 3 days of receipt of the appeal. Now, these are the main clauses. Now I am placing the facts. Well, they have filed this writ petition challenging the order passed on 11 January 2012, that is the last annexure of the writ petition. But in this matter, in this case, what has happened, my lord? They have filed one application for waiver. That waiver was considered and 50% amount of damage charge has been waived. Thereafter, my lord, they have filed re-appeal. That was also considered, but it was rejected. It was stated that we have already passed the order, that is in accordance with law, as such it cannot be done. Thereafter, my lord, they filed one writ petition. My learned friend showed your lordship on the last occasion. They have filed one writ petition. In that writ petition, it is stated that the communication letter which we have communicated to them, no reason order is there. As such, it is directed to the respondent number 3, that is divisional railway manager, to reconsider their appeal. My lord, divisional railway manager DRA reconsidered their appeal and it was rejected, my lord, by letter dated 13th January 2012. My lord, 13th January 2012 is just a communication letter. It is, my lord, kindly see, 13th January 2012, that is last annexure. This is a communication letter communicated by Senior Divisional Commercial Manager, Eastern Railway, Asansol.
So it is not the reason order.
No, reason order, my lord, I have given in my opposition. But it is quoted, my lord, in this letter it is quoted.
So you have not communicated the reason order to them.
My lord, this is the main problem with the railways. They have communicated this order. My lord, kindly come to this page 156. In compliance with the Honorable High Court's order dated 8th December 2011, the waiver appeal against DC and WC in connection with the above subject case has been reviewed by the Divisional Railway Manager, Eastern Railway, Asansol, as respondent number 3, and the following reason order is passed. As per Honorable Court directive, I have again gone through the re-appeal of DC and WC, and one rake containing salt of BLCA wagon was placed at Raniganj Root Sheds at 17.5 hours on 5th March 2010. The wagons were unloaded at 20.40 hours on 6th March 2010. The consignment was finally removed at 20 hours on 8th March 2010. The damage and wharfage was charged. Based on the appeal of senior DCM, has granted waiver of 50% on damage and no waiver was granted on wharfage. I have gone through the appeal of Sri Rameshwarlal Agarwal. Sri Rameshwarlal Agarwal has not given reason of delay in removing the consignment after unloading. Good superintendent report indicates that delay in removing the materials has taken place due to less number of truck and labor. Considering the above points, the re-appeal for further waiver of damage and / wharfage charge is rejected. My lord, I am showing you, lordship, from my opposition the original reasoned order. This is just a communication. Same. That is page 38. Well, it starts from page 38. Your lordship got it, page 38.
Yes, madam.
Well, kindly see the last portion. It is stated DRM. Well, this is the reason order given by DRM. Well, before that, my lord, kindly come to page 37. Well, this is a note sheet on which DRM passed the reason order. It starts from page 37. Well, kindly see at the top, it is stated note. That it is a note sheet, my lord. Well, kindly come to third paragraph. I am placing from third paragraph. 45 BLCA container of salt booked at RR number this and this dated 25 February 2010, placed at Raniganj Goods on 5th March 2010 at 17.05 hours. The rake was released on 6th March 2010 at 20.40 hours and removal was completed at 20 hours on 8th March 2010. GSS/RNG raised DC and WC bills amounting to rupees 67,500 and rupees 1,01,900 respectively. Party submitted first combined waiver appeal on 16th March 2010 and he was asked to submit separate waiver appeal for DC and WC. Party applied for waiver of DC and WC to General Manager Eastern Railway along with demand drafts of the total amount IDD number this and this dated 3rd June 2010. The same was forwarded to this division. Accordingly, considering the merit of the case, competent authority, that is senior DCM Asansol, waived 50% of DC and regretted the waiver of appeal of WC, which was communicated on 13th August 2010. Again, party applied for waiver before the General Manager Eastern Railway and subsequently the same reached this office on 20th September 2010 through CCM Eastern Railway, Kolkata. Treating the application as re-appeal, the matter was referred to DRM Asansol, the appellate authority, and waiver appeal was regretted. The decision also communicated to the party on 23rd May 2011. The Honorable Court observed that waiver appeals were considered and granted without assigning any reason, and on that ground, the orders cannot be sustained in law. Page number 2, para 2 of High Court's order. From the papers of the file, it is found that Senior DCM Asansol passed reason order at page 61 and 62, but only decision of the authority was communicated. My lord, although reason order was passed, but my lord, they have only communicated one line that it is not granted. Similarly, DRM Asansol, being appellate authority, considered the waiver appeal and passed reason order at page number 104 and 105. But only decision was communicated to the party, that is page 106, as per system in vain. Presently, as directed by the Honorable High Court, Calcutta, the file may be forwarded to DRM Asansol for reviewing of the waiver appeals for DC page 77 and WC page 92 and passing of reason order to communicate to the party.
So these are the background.
These are the backgrounds. Now I will show you, Lordship, the report of the goods superintendent. So I will kindly come to page 40 and 41 of my opposition. First, page 40.
Page 40 and 41, what is that?
Well, one is regarding a damage charge, another is regarding workplace charge. Well, this is a report of the goods superintendent. On the basis of this report, it was considered.
Report of the good superintendent.
Well, I have checked that these copies are not released.
Page 40 is legible.
I'm showing you. Can you see this page? Page 40 and 41.
Page 40 and 41.
Yes, my lord. I am placing page 40. My lord, page 40 is in respect
Just a minute. একবার দেখাও তো ম্যাডাম, এটা তো অনেকটা বেটার মনে হচ্ছে।
That is readable. Readable.
only
Original is a readable. It is same.
This portion is not readable. This portion.
Oh, side portion.
Side portion. Huh? Oh. This is the good said superintendent.
Yes, madam. Report of good superintendent.
Just a minute. Why I have handed two papers?
Well, one is regarding damage charge, another is regarding workers charge. Page 40 is damage charge.
Yes. Both are damage charge.
Yes. 2 pages of 40 has been given to your lordship.
Now, kindly see the top subject waiver of damage charge. Your lordship got it at the top subject. Now I am placing this report. Rameshwar Lal Ashok Kumar had booked a rate of 45 BLC 90 placed at Raniganj goods on DD1 at 17/5 hours on 5th March 2010 for unloading, but party failed to unload the consignment within free time and finally released at 20:40 hours on 6th March 2010 and DC accrued rupees 67,500.
This is damage charge.
Well, the next paragraph is the most important paragraph. When the rake was placed at 17:05 hours on DD1 on 5th July 2010, only 2 wagons of salt of previous rake was lying in scattered position for removal and finally removed at 10 hours on 6th March 2010 and WC accrued rupees 1,42,000 of the previous rake.
When the rake was placed at 17:05 hours on DD1,
My lord, only
5/7/2010, only 2 wagons
of salt of previous week was there.
week, was lying in scattered position for removal,
And finally removed at 10.
10 hours.
10 hours means 10 a.m. on 6 March 2010.
And
My lord, kindly see. Suppose this is the total wagon. In this, this is the total rake. One rake consisting of 45 wagons. My lord, as per this report, in front of the rake of the petitioner, my lord, only 2 wagons are there. Only 2 wagons. 43 wagons are free to unload. My lord, kindly see the.
when just a minute, when but party failed to answer. When the rake was placed on ASTO on DD1 on Pfizer, only 2 wagons of salt of previous week was lying for removal and finally removed on ASTO. Yes.
If this is the total rake, my lord, only 2 wagons are there in front of the rake of the petitioner.
It's not correct. My lord.
As per this report, my lord, only
This report says otherwise, my lord.
No, Mr. Agrawal. Please.
only 2 wagons are there, my lord. The remaining 43 wagons are free to unload. Next paragraph, my lord. Parties surrendered ORR on 6 March 2010 at 8:30 hours and took delivery and started his unloading work and finally released at 20:40 hours on 6 March 2010. Rameshwar Lal Agarwal appeal for replacement. My lord, this paragraph is also important. Rameshwar Lal appeal for replacement at DD2 on 5th March 2010 at 20:50 hours instead of DD1 after placement of rake in DD1. But there was some operational constraint and the same is supported by the station manager Raniganj. My lord, the rake was placed at 17.5 hours. But he appealed to the authority for changing of the track from DD1 to DD2 at 20:50 hours, means 8:50 p.m. in the evening. So, my lord, from 5 p.m., 5:5 p.m. to 8:50 p.m., he sat idle. He has not done anything.
Yes.
Well, this is the important portion. Thereafter, my lord, kindly come to the last portion. The waiver appeal received on 27th July 2010.
Now, what is paragraph 2? Rameshwar Lal is a regular merchant
and in every case, damage bill are served after final release of the rake. Being a regular merchant, it is also known to him when DC is
start in operation.
The party was informed / advised to place separate waiver by letter dated 23rd March 2010 in separate to the waiver appeal dated 16 March 2010. This is as per rule. GSS RNG received demand draft of demand draft we have received, there is no. So, my lord, as per this statement, only 2 wagons are there in front of the rake of the petitioner. Other wagons are free to unload. And secondly, my lord, he has appealed to the authorities at 8:50 p.m. on 5th March 2010. When my lord,
so is that vital?
Yes, my lord.
Why?
But he has taken a point that although we have requested to shift the track, but they have not shifted it.
Oh, for change of the line.
Change of the line.
DD1 to DD1 to DD2.
Yes.
Yes. Yes.
And next is page 41.
Page 41. Yes.
Regarding warfare charge. At the top it is stated subject waiver of warfare charge. You also got it?
Yes.
Rameshwar Lal Ashok Kumar had booked a rake of 45 PLC and placed at Raniganj goods at 17.5 hours on 5th March 2010 on DD1 for unloading and finally released on 20:40 hours on 6th March 2010. Party could not remove his consignment within free time and finally removed his consignment at 20 hours on 8th March 2010. and WC accrued rupees 1,01,900.
So far this timing is concerned, I believe is not
No,
disputed.
no.
So I am to
Timing and rate, there is no
decide whether he is at fault or you are at
You are
fault. This much.
dispute.
But so far this
But,
timing has
there
concerned
is
is
no
not
dispute
disputed.
regarding timings and rate. No dispute.
Very
For the next paragraph, party could not arrange extra. This paragraph is important. Party could not arrange extra more labor and truck for removal of the consignment. On 7th March 2010, 42 BCN MT was placed at 14:30 hours on DD2 for outgoing loading.
Just a minute, madam. Party could not arrange extra more labor.
My lord, it's
Labor means for removal of the
labor.
sacks or something.
Labor will take out the goods, madam.
And truck. Oh,
For
party could not arrange extra more labor and truck for removal of the consignment. Very good.
My lord, our case
Then
is that on 7th March 2000, MT was placed at 14:30 hours
on 7/3/2010. What?
No, it is regarding another case regarding unloading of cement. On 7th March 2010, BCN MT was placed at 14:30 hours on DD2 for outward loading of cement and completed at 8:30 hours on 8 March 2010. Hence, limited manner according to this statement, there was limited labors. As in another consignment, the labors were already engaged. As such, there was
So it is not relevant for us.
no.
On 7th
But there is scarcity of labor
on the part of the
petitioner.
so party could not arrange extra more labor and truck.
Yes, my lord. My lord,
So according to you,
unloading will be done by the labor.
just a minute. Please ascertain whether I have understood your contention or not. Which is why I am asking you a question. The goods sales superintendent reported that party could not arrange extra more labor and truck for removal of the consignment. Which is why you have charged warfare charges.
Yes, my lord. As their labors were
Though it is the case of the writ petitioner
that there was
warfare was not available,
yes, my lord.
for which delay was occurred, and naturally further delay was occurred from removal of the goods from the work.
Yes, ma'am. Yes, ma'am.
That they are railway premises.
Yes.
That is their contention.
My lord, as per this statement, their labors were engaged in another consignment. As such, in this consignment, there were few labors.
Where from will get that?
Well, the next slide, on 7th March 2010, BCN MT was placed at 14:30 hours on DD2 for outward loading of cement and completed at 8:30 hours on 8 March 2010. Hence, limited labors at Raniganj goods were divided into two parts and party have to face scarcity of labor.
No, the consign is same.
Same manner.
Ramesh sir.
No, I do not do.
As per this report, it is same. But kindly see the language. On 7th March 2010, 42 BCN MT was placed at 14:30 hours on DD2.
They are on DD1.
This consignment is at DD1. This consignment regarding salt, and this is in respect of cement. And in DD2 there was a consignment
containing cement.
DD2 for outward loading of cement. Outward loading of cement.
Madam, I have understood.
And
but because of unloading of the consignment of cement from DD2,
their labors were divided. As per this statement, their labor loading of cement and completed at
divided
8:30 hours
into two parts.
Hence, limited labors at Raniganj goods was divided into two parts, and party have to face scarcity of labor.
Very good.
Their consignment or any other consignment, but there was scarcity of labor. This is the main point. Rameshwar Lal appealed for replacement at DD1 on 5th March 2010 at 20:50 hours instead of DD1 after placement of
same content.
But have some operational cost as such same is supporting. Next is also same. So,
So,
my lord,
in respect of waiver of damages, the report of the good superintendent was that DD1 was fully occupied is not correct. Only two rakes are there, and some
my lord, only 2 wagons are there, not rakes.
no, I'm sorry, 2 wagons are there.
1 rake means 45 wagons. Only 2 wagons are there. My lord, 1 rake means 45 wagons.
That I've understood.
Only 2 wagons are there in front of the rake of the petitioner.
And some consignment was lying scattered in a haphazard manner.
2 wagons of salt of previous rake was lying scattered, and that was also removed at 10 a.m. in the morning on 6th March.
When the rake
suppose-
was placed on Atho, only 2 wagons of rake was lying in scattered position
For removal,
and
finally
removed
removed at 10 hours on 6th March 2010. 10 hours means in the morning, 10 a.m. in the morning.
Yes, I know. And WC warfare charges, work charges occurred for rupees Atho.
My lord, in front of their rake, there was only 2 wagons. My lord, other 43 wagons are free to unload. They can unload from that wagon.
Very good. I understand. Anything more? So, while passing the reason order, reliance has been placed upon these 2 reports.
Yes, my lord. As my lord, I have shown you, I have shown your lordship the provision that regarding waiver, my lord.
Huh.
Well, as per clause 2.5 of that circular, my lord, circular number 39 of 2004, the concerned station manager and chief goods supervisor will forward the application of waiver along with their report stating the factual aspect. On the basis of their report, it will be decided whether their waiver application will be entertained or not. Well, I want to show you, your lordship, the statement of station manager, that is at page 39. My lord, page 40 and 41 is a report of the goods superintendent, and page 39 is a statement of station manager. The lordship got it? Page 39.
Just wait. I got it, but I have to note. For which I should
No,
not pay.
Written notes are
For which I should not pay any damage or work charge. Yes.
In connection to the above subject, the following informations are given for your kind consideration. 45 BLCA salt arrived at Raniganj at 16:05
So
hours.
when 2 reports have been submitted, what is the necessity of filing this one, page number 39?
It is not necessary.
Anyway, place. What is this? The page 40 and 41 are the reports. Then what is page number 39?
39 is a statement of station manager.
Statement during hearing.
Yes, no, during this consent. During not during hearing, my lord. This is the statement given on 30th July 2018 after receiving their
Station manager. Anyway,
after receiving the appeal, we take a statement from the station manager and the report from the goods superintendent. On the basis of
so
this,
after filing of appeal.
After filing of appeal for waiver.
And this is with regard when forwarding the damage application.
Yes.
Very good.
In connection to the above subject, the following informations are given for your kind consideration. 45 salt wagons arrived at Raniganj at 14 hours on 5th March 2010 and was placed on DD1 line at 17.5 hours on 5th March 2010 when the other line, DD2 line, was blocked by 42 BCM empty of cement, which was yet to be drawn out. The appeal for replacement from DD1 to DD2 was received at 20.35 hours on 5th March 2010, and the same was brought to the notice of Chief Controller Asansol, but due to non-availability of shunting pylon, the replacement could not be done. Well, it was placed at 17.5 hours, but they have made,
Did you want?
Huh?
When the other line detail was blocked by
But they have made the request on 20.35 hours. To show this, I have placed this statement, my lord.
It was already there.
It is already there.
So according to you, this report supports the
Yes, my lord. Good
good
superintendent.
superintendent office. So it is at par with 40 and 40,
Yes.
41 and 40.
41 and
40 and 41. 40 আর 41 তো। It is
Now I am showing your lordship the calculation. Before I am going to the calculation, my lord, I want to. My lord, kindly come to page 35 of my opposition.
there is a finding.
Yes, my lord. My lord, on 13th August 2010, we have considered their appeal and we have reduced the damage charge by 50%. My lord, based on this reasoning, although we have only communicated to them one line that it is reduced to 15%, but the reasons given in this note sheet. My lord.
No, why are you not showing the
But I am showing the note sheet, the reasons given in
reason given
for
after reconsidering the appeal,
their appeal.
which is has been communicated before this court?
Only we have communicated the result of the reasoning,
Very good.
not the total reasoning. My lord, page 35.
Huh.
But kindly come to the last paragraph of last paragraph. However, Mr. Rameshwar Lal Ashok Kumar is a regular customer.
Give me a second, madam. Give me a second. No, why are you saying so?
No,
Because
my lord,
your ultimate reason order comments from page number 37. Then
my lord, I'm just showing the reasons given before by the
no, that has been placed before the earlier coordinate bench. Earlier coordinate bench was not
this
satisfied.
reason order has not been placed. The earlier bench set aside the communication letter by stating that as there is no reason in the communication letter, as such you are directed to reconcile.
Very good. Then I am not concerned about that. So for the timing, you place the reason order,
yes,
which has been communicated by the impugned letter. That is at page number 37. You said.
Yes, my lord.
So place that. Why should I go back to that?
And that is one line. It is only it has been reduced to 50%. Well, in page 33, we have given the reasons.
Oh, you say that the impugned letter, which contains the decision,
yes,
you have taken a decision pursuant to the order passed in WP number 1045.
Yes, madam. Communication letter is at page 156 of the writ petition, and the reason order is at page 38.
It comments from actually page 37, which is a note sheet.
Yes, madam.
And the relevant portion is at page number 38. So place that order. Yes. If there is any perversity, it will be rejected. It will be set aside. If there is no perversity, if there is a reason, appropriate order will be passed.
It starts from page 38. As per Honorable Court's directive,
just a minute. So it is DRM, no?
DRM. But the Honorable High Court directed the respondent number 3, that is DRM, to consider the appeal.
So this is the reason order.
This is the reason order.
In the note sheet.
Well, this order has been passed on 11 January 2012, although it has been communicated on 13th January 2012.
Reason order dated
11 January 2012.
Yes, now please.
As per the Honorable Court directive, I have again gone through the re-appeal of damage and warpage on one rake containing salt of this BLCA wagon was placed on Raniganj goods shed on
17.5
on 5th March 2010. The wagon was unloaded at 2.40 on 20.40 on 6 March 2010. The consignment was finally removed on 8th March at 8 p.m. 20 hours. Damage and wharfage were charged based on the appeal. Senior DCM has granted waiver of 50% on damage and no waiver was granted on wharfage. I have gone through the appeal of the Rameshwar Lal Agarwal. Sri Rameshwar Lal Agarwal has not given reason of delay on removing the consignment after unloading. Goods superintendent report indicates that delay on removing of material has taken place due to less number of track and labor deployed by Rameshwar Lal Agarwal. Considering above point, the reappeal of further waiver of damage / wharfage is rejected. Well, the main reason is due to shortage of labor and truck. They could not unload and they could not remove the materials from the railway premises. Well, the calculation, well, I am placing the calculation. Well, kindly come to page 29. Well, there is a typographical mistake in my opposition at page 4. I have stated, well, kindly come to page 4, which my learned friend wrote to your lordship.
Yes.
Well, here we have stated that, my lord, the GSS Raniganj noted down actual time of unloading and removal of materials against respective wagons and finally imposed wharfage charge against materials of 21. It will be 35, my lord, not 21. Now, my lord, kindly come to the calculation page. Page 29. Well, page 29, your lordship got it? Page 29. My lord, here we have calculated the wharfage charge in respect of 30 wagons. Total, there were 45 wagons. They have shifted 10 wagons, but they could not shift 35 wagons within the free time.
But it has been written as 35?
My lord, we have calculated the wharfage charge on 35 wagons. At the top, it is stated, my lord, 35 wagons. We have calculated
18 this side, left 17 that side. Mr. Agarwal has told no? Wagon, left hand column, wagon number is total number of wagon 18 and this side is 17.
Yes, my lord, total 35. Total 35.
That way we have said.
Yes, total 35.
So for my recollection goes. Yes, sir. Yes, madam.
My lord, page 29 is in respect of wharfage charge. My lord, the rake arrived on 5th March 2010 at 5 p.m. means 17.5 hours. And my lord, the time starts from 6 p.m. on 5th March 2010. As per the circular I have shown to your lordship. My lord, the rake arrived at 5 p.m., 5.5 p.m. and their time will start from 6 p.m. As per
Since it becomes operational from 6 p.m.
Yes, my lord. My lord, can you see the heading given? Wharfage statement of 35 BLCI/salt under invoice number this and this placed at 17.5 on 5th March 2010. Wharfage charge after expiry of free time for removal up to 18.5 on 6 March 2010. My lord, in the column, kindly see the time given.
Welfare charge after expiry of free time
Up
for
to-
removal up to 18.5.
My lord, 12
Also,
hours.
12 hours, yes.
My lord, time starts from 6. My lord, it entered the track at 5:5 p.m. on 5th March 2010.
17.05 hours.
17.05. Time starts from
6 hours.
6.
On the next day.
No, not next day, that day.
Oh, it is up to
As per the
22 hours, no?
As per that circular, my lord.
22 hours. From 6 hours to 22 hours.
My lord, the total free time is
No, operational time is
9, 4, and 12. 9 is free time for unloading. Another 4 hours is given if it is in the night. Total free time for unloading.
just a minute. Let me check one second.
But there are two aspects. One is unloading from the rake. Another is
Removal.
from the railway premises.
Just a minute. Let me check once. Page number 31, na? Permissible free time is for unloading 12 hours
12 hours.
and after unloading another 12 hours.
No, my lord.
No.
Free time for unloading is 9 hours in the day and 4 hours for night. Total is 13 hours. For unloading is 13 hours.
Where from I will get that?
My lord, my lord, kindly come to page 17, the circular. Page 17, circular. Rate circular number 74 of 2005.
Yes.
My lord, page 18 is the relevant clause 2.2, 9 hours.
9 hours. Free time for loading and unloading of wagons.
Yes,
9
my
hours.
But in this case, loading is not there, only unloading. They have to unload the wagons from the wagon to the railway premises, in the platform. They have to unload it within 9 hours free
9
time.
hours.
Another 4 hours had been given to them as it was in due to the night.
Where from I will get that?
But that circular I have not annexed. That is an admitted position. He has also admitted that.
Achha. 9 hours and plus 4 hours.
না এই বটনটা তো অন্য জিনিস না এটা তো অন্য জিনিস লাইট স্টপ বলা
Yes.
no that is in another circle.
So it is 9 hours.
9 and 4 hours.
Yes.
We have given them 13 hours free time. We have given them 13 hours.
Achha. Now come back to page number 29.
Page 29, my lord. My lord, I have shown you lordship one clarification regarding that is page 24, my lord. I have shown you lordship one clarification regarding the rate circular.
Damage charge will be levied at the rate of for 8 wheel per hour or part of an hour.
Just a minute. My lord, I have shown you lordship one clarification dated 17 March 2010. That is at page 45 of my opposition.
Yes.
This is a clarification. A clarification has been sought as regards reckoning of free time for a rake which has been placed on a line where free space is not available on adjoining platform due to non-removal of consignment unloaded from other rake. The matter has been examined and it is clarified that commercial placement of a rake will commence from the time of its operational placement in the railway goods shed / siding, irrespective of the fact that unloading slash loading could not be commenced immediately for reasons such as non-availability of free space on adjoining platform, non-availability of covered shade, rain, etc., provided that such time of operational placement lies within the working hour of that particular railway goods shed slash.
So it was placed at the operational time.
Yes, my lord. So, my lord, they placed the rake at 17.5 hours. As such, operational time will start from 6 p.m.
18 hours.
18 hours on the same day. My lord, on the last occasion, Mr. Agarwal argued that as per the clause, after unloading, the time will start. After unloading of the materials, the time will start for removal. That is not the case, my lord. It is clarified that the time will start from 6 p.m. in this case. My lord, one illustration has been given.
So, madam, what I'm on, if it is placed on DD1 at 17.05 hours, it will start from there immediately thereafter.
Immediately thereafter.
Not one after. 1 hour after.
My lord, here we have started. We have counted it from 6.
No. If you kindly come, say working hour of a goods is 6 to 22 hours.
5.5. It was placed at 5.5. That is why we have counted it from 6.
But these
A fraction due to the fraction.
No. So for page number 45, that is the clarification
Yes,
is
my lord.
concerned. It does not say about grant of any excess 1 hour.
Yes, my lord.
That I am on.
Yes, my lord.
So it has to be started immediately.
Immediately.
But according to you, you have given extra 1 hour.
Yes, my lord. 55 minutes.
55 minutes. Very good.
Now, my lord, kindly come to page 29. My lord, the first wagon. My lord, kindly see the time 7. It was removed at 7 on 7th March 2010. It comes to 13 hours. Well, the time started from 6 p.m. on 5th March 2010.
Yes.
And it was removed at 7 p.m. on 7th March. As such, the time was calculated as 13 hours. Your lordship got it? $13 thereafter, my lord, 18 hours.
It was placed at 17.5 hours. You have started calculating at 18.5 hours. So free time is on the next day at 6 a.m. But it was removed at time is I'm sorry. Free time for removal up to 18.05 hours. 24 hours, not 20.
Well, 12 hours was the free time. 12 hours.
Well,
from 17.5 to 7, it should be 17.5
to 5.05.
12 hours. Yes, my lord. It should be, we have calculated it from 18.5 to 18.5.
So it should be it is 6.5.
6.5.
On the next day.
Next day. In the morning. That is why it is stated, my lord, free time for removal up to 16.5 on 6 March 2010.
Yes.
Your lordship got it?
That I have got it.
Thereafter, we have calculated.
No, when they have removed?
My lord, first wagon was removed on 7th March 2010 at 7 p.m. Second wagon was removed on 7th March. Thereafter, my lord, the time.
So if they are supposed to have you given them 24 hours?
My lord, the last wagon, my lord, kindly see the last portion, 50
No,
hours.
tell
They-
me one thing. You have given free time for up to 18.05 hours. That means you have given 25 hours.
No,
Kindly check.
18.5 on 6 March. 6 March.
So it
5th
comes
March.
to 25 hours.
Less 12 hours. Less 12 hours for free time, according to them. 13 hours for unloading and 12 hours for warfare. This is warfare.
No, no, no.
This is warfare. And that's why 25 minus 12, they have to charge for 13 hours.
Twelve hours for unloading and
Unloading.
12 hours for removal.
13 hours.
13 hours.
13 hours for unloading.
My lord,
9 plus 4. 13 hours for
my lord,
unloading.
it is not that after unloading they will start removal. It is not that. My lord, suppose this is the rake. Only this portion, only 2 wagons are
That
there
I've
out of the
understood.
rake. Others are free. My lord, they can start, my lord, for unloading. First
No,
they
no,
have to-
I want to know how you made the calculation. That is
My
a
lord,
little bit confusing.
my lord, first they have to unload the goods. Thereafter they have to remove the goods. My lord, that's why we have started the calculation by taking the time from 6 p.m. on 5th March 2010.
Very good. Which is why you have calculated 13 hours.
13 hours. My lord, kindly come to the last portion, my lord.
Yes.
My lord, see last, my lord. Kindly see the hours, 50 hours.
Which one?
My lord, the second column,
Yes, 50 hours.
50 hours. Well, this is due to their fault. They could not remove the goods from the railway premises. My lord, the wagons which were in front of the rake, that was removed in the morning on 6th March.
That
As
report
per
has
the
been.
report. As per the report, it was removed. At
So there
10
is no
a.m.
wrong in the calculation.
There is no wrong in the calculation.
That's all.
Again, my lord, I am submitting that this is the application for waiver. It is our discretion. We will consider it on the basis of our report, on the basis of the report of the goods superintendent. They could not produce any document before your lordship that how much it was locked. It is on the basis of the report of the goods superintendent it was considered.
That's all.
But they have not produced any evidence that it was blocked. They have not produced any evidence.
So no contrary evidence has been placed.
Yes, my lord. On the basis of the goods superintendent's report, it was considered.
Take down.
In reply.
Minutes, sir. I have to go to another division.
Yes,
bench.
yes, I know, madam. I'll give only 2 minutes in reply because something has been
Not
placed.
in facts, sir. If there is a law, you can say.
Yes, madam. No, in fact, there are certain things which have been not actually placed. Only 2 things. One, your lordship, I have shown the circular that it should be after unloading. That 12 hours should be counted after unloading, but that should not be merged with 13 hours. 13 hours for unloading and then removal for 12 hours. So 12 hours will start from the time of completion of unloading and not from the time of 13 hours. One cannot be in double jeopardy that you have unloaded belatedly, this charge will have to be paid, and you have not removed from the wharf, these goods did not come to the wharf for that.
So 12 hours will start from unloading and not
From
from
unloading time, admitted unloading time. I am not disputing unloading time.
and not from
The time, free time for unloading.
not from the expiry of the free time.
Yes, my lord.
Very good.
And so far as my lord evidence is concerned, I am relying upon their own evidence. Only one document I shall show your lordship, my lord. Their report that it was scattered. Scattered means not that block. Your lordship knows, my lord, a railway rake comes on a platform. Until the entire rake is unloaded, 2 wagons cannot be placed and 43 wagons have been replaced. That cannot be. What my learned friend has submitted. Fact remains that stock of 2 wagons was lying on the wharf in scattered position.
Shall I file written notes of argument?
Scattered position.
If I require, if I feel that I am facing difficulty, I shall place the matter in to be mentioned.
This is very complicated.
No, I have noted it extensively. It would be better if I hear you on at a time. Anyway, it cannot be done.
Only, my lord, only one document that the salt of earlier rake was scattered on the platform,
That I'll take care of it.
my lord. And my lord,
Ashun. Hearing is concluded. Judgment is reserved. Hearing is concluded. And judgment is please
page 128 says the grounds. The SDM did not consider section 82. SDM did not consider the consignment was not ready for delivery, and SDM did not consider that free time allowable for such and such are ready for delivery. There's ground number 5, 6, and 7.
Very good, sir.
Only these two things.
I shall consider.
That's why I think your lordship made CAV.
I had to make because I
Yes,
have
yes,
to
your lordship
approach
is seat at 12, my lord. I
ये 12 होगा which assist to Prasad ji bata kya আর কি করে হবে
And these calculations.
The contempt matter, what is Mr.
Lordship,
Calculation has been done.
Lordship, we have just received the calculation.
Hand over a copy to the learned your adversary and it will be taken up on Monday. It will remain as it is. এই সোমবারে এটা থাকবে
Lordship,
কল্যাণ
we wish to file an exception to this calculation.
Oh, you are for the repetition.
Applicant, yes, Lord.
So you come
On
with an exception on that day.
Great.
Monday. I'm not recording any order.
My lord, may I just indicate the corrections I've made, suggested corrections in the order? All marked in, I've marked it with pencil.
No, it's all right. Since two identical matters are there,
Yes,
which
my
is
lord.
why
Yes, my lord.
figures have been.
Yes, my lord. The figures have been replicated. That's all. Page numbers also, my lord. There's a slight difference. Not in all the 3 pages I've indicated with.
Give me a second. So instead of 25 lakhs, it should be 70 lakhs.
70 lakhs, my lord. And out of that 70 lakhs, 10 lakhs has been paid by them. In the next page, my lord, second page, 8th line. And my lord, in the last page, my lord,
2015, it should be 2000, of course.
I am appearing on behalf of the decree holder, Your Lordship. Pursuant to Your Lordship's last order for paper publication, we have made such publication. Your Lordship was pleased to direct to cause publication in daily newspapers in Patna Circle, in an English newspaper. But Your Lordship, just for an abundant precaution, we had published one in English newspaper and one in Hindi newspaper in the Patna Circle,
One in English newspaper.
as well as in Hindi.
Oh, it was either or, but you have made both.
Both.
Very
Both. একটা করে গেছি পাতলাম পড়ার আছে বেশি জ্ঞান হয়েছে তোমার কাছে থাকি তোমার কাছে থাকে Your Lordship, all the publications Your Lordship will find upon unfolding on the right side. In the English, Your Lordship kindly unfolds the newspaper and turns over the page. No, there, Your Lordship, there are two sheets on the right side. Utkarsh India.
Limited.
Yes, Your Lordship.
To Aparajita Enterprises.
Yes, Your Lordship.
And to Navneet Vasta.
Yes, Your Lordship. One of the partners of the firm Proceedings Enterprises.
The name of the witness is the Honorable the Chief Justice.
Your
It is
Lordship.
in the form.
Your Lordship.
The name of the witness is the Honorable the Chief Justice.
Your Lordship. Your Lordship kindly allows me to go through it once.
Witness, the name of the Honorable the Chief Justice. It is in the
এটাতে কোথায় in the decree, Your Lordship.
no. In the here. Just see the last part. 1, 2, 3. Your name is Mr. Basu, no?
No, Your Lordship, my solicitor.
What's your good name, sir?
Oyon Dotto.
Mr. Dotto, just see the name of the Mr. Deepraj Basu.
Yes, Your Lordship.
Just over that witness.
Yes, she was my name. Yes, Your Lordship. The Honorable Chief Justice.
It is being done. Of course, the draft has been approved by the department.
Yes, Your
It is
Lordship.
only for the curiosity.
Yes, Your
Witness name has been Chief Justice.
Your Lordship, perhaps the decree, Your Lordship, any decree passed, the decree could come to.
No. I'm not asking any legal point.
No,
I'm
no.
asking-
But in the decree, there will be the. Your Lordship kindly takes the petition. Kindly takes the petition towards the end. It has to be. Your Lordship, towards the end of the decree, it's always the witness, the Chief Justice of India. Okay. No, Your Lordship. Your Lordship, I am only praying for issuance of warrant of arrest. Your Lordship, the warrant of arrest is to be issued. Your lordship will direct for the issuance of warrant of arrest. From the department, it will be done, your lordship. Department.
It was directed upon a particular officer to execute the warrant of arrest.
Yeah.
That procedure I want to know. Exactly on that.
And your lordship kindly then refer to
15. Every warrant for the arrest of any person in execution of a degree or order shall, in addition to the amount,
14
similar to
your lordship kindly come to 14C.
the court appointing such a sufficient ground exists for increasing division of such police. No, 14C is for police, sir.
Yes, your lordship.
For police for execution of the degree.
Yes, your lordship.
We are on execution warrant. Come to 15.
Yes.
Warrant
of arrest, cost of
every warrant for the arrest of any person in execution of a degree or order shall, in addition to the amount due and payable under the degree for principal, interest which is a sum for the cost of the execution as shown in the table below. So it may be there. warrant of attachment, return of warrant. Every warrant of arrest or attachment shall be
Your Lordship, I
18. Returnable by the sheriff to the office of the registrar immediately after service thereof. Unable to serve the same, not also.
it could be possibly it ought to be routed to the our registrar's office.
Sure. Do you want to
It's do 18, your Lordship. What?
just একটু এসিটা বন্ধ করানো হয় অ্যারেস্ট এন্ড ডিটেলস ওই ওয়ান you are Mr.
Oyan Doctor.
Dotto.
Yes, your Lordship.
So Dotto, come to page number, I'm sorry, order 21 rule 3081. Have you got any book?
Your Lordship,
May I?
Accessing. I am at order.
Order 21 rule 38.
Order 21 rule 13.
38. Warrant for arrest to direct judgment letter to be brought up.
Yes, your Lordship.
Kindly place.
Yes. Every warrant for the arrest of a judgment debtor shall direct the officer entrusted with its execution to bring him before the court with all convenient fees unless the amount which he has been ordered to pay, together with interest thereon, and the cost, if any, to which he is liable, which do not pay.
Then place order 39, rule 39.
Rule 39, subsistence allowance.
Yes.
1. Subject 1. No judgment debtor shall be arrested in execution of a decree unless and until the decree holder pays into court such sum as the judge thinks fit, sufficient for the subsistence of the judgment debtor from the time of his arrest until he can be brought before the court. Subrule 2. Where a judgment debtor is committed to the civil prison in execution of a decree, the court shall fix for his subsistence such monthly allowance as he may be entitled to.
So for the timing we are not. We are concerned with
Yes,
38 and 39.
Yes, your Lord.
No judgment in execution unless and until there is such sum as the judge thinks fit for the subsistence of the judgment debtor from the time of his arrest until he can be brought before the court. So this is 38 and 39. Let me check whether in the code of civil procedure, in the any form of warrant of arrest is there or not. It is there in the code of criminal procedure, but in the you practice in criminal side? No, which is why I'm asking. Let me check once. So sometimes, Mr. Dotto, at the time of doing cases, academic discussion is required.
Absolutely. I bow down. I bow down.
Let us check any form is provided in the schedule or not. Order 21.
30 in appendix.
Of course. Come to form number 12 and 13.
Appendix.
Appendix E. Yes, sir. Order 21, Rule 37 deals with the discretionary power to permit judgment to show cause against the detention in present. Notwithstanding anything in these rules where an application is for execution of decree for payment of money by the arrest and detention, the civil present of a judgment is liable to be arrested. In pursuance of the allegation, the courts had, instead of issuing a warrant of arrest, issue a notice calling upon such and such to appear before the court on a date to be specified in the notice, and so called wise he should not be committed to civil prison, provided that such notice shall not be necessary if the court is satisfied by affidavit or otherwise that with the object of or effect of delaying the execution of the degree, the judgment is likely to abscond or leave the local limits of the jurisdiction of the court. Where appearance is not made in obedience, the court shall request issue a warrant of arrest, then order 21 to 38 to the bailiff arrest. So it is to the address to the bailiff of the court. He is to execute the warrant of arrest. With the help of the local police station. So far, Appendix E, clause, form number 13 is concerned.
Yes, but your lordship, if I may, your lordship,
Huh.
kindly, if we go, if I can draw your lordship's attention to chapter 1714E.
Chapter
17. Chapter 17 of original title.
original setting. Just that I wanted to see. Chapter
1714. Uh, please why I am referring to this, your lordship, although it is with regard to police help, if I may please once, 14C, the court upon being satisfied that a sufficient ground exists for requisitioning such police help may direct the registrar to request the commissioner of police to render such help to the decree holder. Now, your lordship, kindly on this name, I kindly allows me to place 14A. The provisions of Rule 14A to E will also apply to execution of orders for possession, warrant of arrest. So possibly subject to correction, your lordship, this direction will go toward to the registrar as per in compliance of 14C.
that I intend to know. In the tabular statement, have you made any prayer for arrest?
Yes, your lordship. Kindly comes to prayer D. An order be passed directing the officers of the judgment debtors to be imprisoned for such term.
Very good. Ashu.
And the find the provision actually through, it has to be
Take my
through the
book.
ship.
Take my book. Take my book. Hey, put it out, you know. It's very difficult to read in. So this type of job is probably done in a seldom manner.
No, your lordship, it's quite common.
Common.
Quite common. Your lordship, may I draw your lordship attention to Rule 18.
Look, বলেছিলেন না। Yes.
Finally, every warrant of arrest or attachment shall be returnable by the sheriff to the office of the registrar.
So which is why I'm doing.
Yes, your lordship.
Sorry.
That is what I.
ওটা কি লিখলাম last line টা?
My lord will kindly ensure the order just passed gets reported. Because this now holds the law with it. We usually, my lord, stereotypically go on with warrant of arrest, but now your lordship has laid down the source of law and what is the exact.
No, sir. What I'm on.
An execution proceeding which is coming up for the first time
Yes.
in view of, my lord,
When the degree was passed.
yes, that is August 9, 2024.
August 9/20. So when it was put into execution.
Yes, my lord, we have, my lord, put this
So within 2 years.
within 2 years.
What is the nature of the degree,
My
sir?
lord, it's a simpliciter case for recovery of money lent and advance. If your lordship kindly sees, my lord, the operative portion of the order is at page 31.
No, show me the degree, sir.
That is
I
the
want to
degree.
see the degree. Yes.
That is, my lord, it begins, my lord, from page
Page 19.
24. Begins from page 24.
No, what is page 19 then?
Is a subsequent modification of some typographical errors.
Page 24.
24, my lord, the decree, judgment and decree begins.
Hmm.
And, my lord, the operative portion is at page 31.
So this is the order, no?
Yes, this is the order. And after the correction made on September 2, 2024, both has now become a part of the decree.
So this is the original order.
Yes.
And what is the corrected order?
Page 20, September 2, 2024, page 22. There was no correction, my lord, on the quantum. It was only some typographical errors which were corrected.
So the digital amount remains
Remains
same.
the same. Yes. And your lordship, my lord, can rely on the tabular statement where the digital amount is mentioned.
The defendant is directed to pay rupees 10,000 being principal amount,
Yes.
along with interest at 15% annum.
And
So
cost-
degree has been drawn up.
Yes, yes. That is the reason by pursuant to which we are before your lordship. My lord, may I, my lord, assist your lordship?
Give me
The
a second. Give me a second.
Yes.
10,000 being principal amount.
10 lakh.
I'm sorry, 10 lakhs being principal amount along with that. Yes.
My lord, on the last week, 2 matters were before your lordship, where your lordship was pleased to, my lord, pass an order that was against the same judgment debtor, Neelkant Shaha. With your lordship's leave, my lord, I have indicated some corrections because even the properties are same, over which I am seeking for injunction on this very first day. With your lordship's leave, my lord, may I, even the amount is also, may I hand up? My lord, I have with leave, my lord, indicated the corrections in pencil.
Oh,
This is for your lordship's similar assistance to the extent I could have.
it is a Dokindari road or something
Yes,
like that,
yes,
no?
Lord, it's absolutely same. Paragraphs 8 and 9 are also.
Account numbers are same.
Yes, Lord. It belongs to the same person who is a common judgment debtor in the order I have handed over, as well as the decree which is under execution before your lordship.
So you want similar order.
Yes, my lord, it can be, my lord.
So only
the amount, my lord, only the amount changes.
portions which are required to be changed that has been indicated.
I have indicated. Your lordship can also, my lord, be pleased to keep this matter on 21st March because it relates to the same decree holder. The other 2 matters are kept returnable on that date.
আসুন দেখি এইটা ওই একই ডেটে রাখতে বললেন তো
Item number 4, my lord, I appear for the decree holder, my lord. My lord, pursuant to your lordship's direction, my lord, I think, my lord, process was served because I think we are praying for adjournment. Lord,
Why,
there is no
sir?
question of any adjournment under order. Lord, Rule 41, my lord, he has to file his affidavit of assets. So let that direction be passed, my lord, he will get some adjournment anyway.
Why are you seeking adjournment?
Your Lordship, we got the copy yesterday.
It's a decree, my lord. They were aware of it all the time. Well, lord, the decree has not been satisfied for over 30 days from the date of decree.
What is
he
the
has to
nature of
file
the
his
degree?
money decree, my lord.
What is the amount of the degree? Show me the certificate copy.
Lord, lordship will kindly take the tabular statement.
Show me the certificate copy of the degree.
Certified copy. That is at page. Annexure A, but it is not marked in my vote.
To the plaintiff, says such and such, aforesaid degree total sum is 22 lakhs 46 or 524.
Yes,
22 lakhs
and
40 or 500.
till date, plus interest, it has become around, around 50, more than 50, I think. Tell me.
But as on 31/12/2024, it is 51,63,000 including interest.
Inverse है तो जनरल प्रिंसिपल है ना inverse है पूरी जगह होता है commencing from the 9th day of March in the year 2014. Sir, which is why I ask you people to refer to the degree. Come to the come to the internal page 5 of the degree, sir. Page 17. Have you got it?
Yes.
Come and it is read from here. 1, 2, 3, 4, 5, 6, 7, 8 line from top. The sentence start from with and it is.
The order and decree that the state also
Said plaintiff petitioner.
interest on aforesaid decretal sum of rupees 22 lakh at the rate of 12% per annum commencing from 9th day of March in the year 2014.
Very good. Now come to your tabular statement.
Malan.
Column 7.
Yes, Malan.
Add interest
Calculated at till 31st.
commencing from
It should be from the date of the invoice only. Malan.
no. It has been indicated in the degree. Which is why I ask you to show me the degree first. From the 9th day of March to 2014. So why it is written?
No, from is not it.
Then
That I can still come back with a supplementary affidavit indicating the calculation also.
you amend this portion. Have you made the calculation from that day?
It should be, Millard. I can clarify that by a supplementary affidavit. I can indicate the whole calculation.
So what is the predicament in making an amendment application?
So that will take more time. That's all. Millard. Because Millard, I hope that it has been calculated from that as per the decree only. So, Millard, to clarify that, I can come up with the calculation also.
No, you have to carry out the amendment.
From is not written. Millard, I bow down to your lordship. Millard, it is written till, so it would from this portion it won't appear. From which date.
In course of here. was it served?
And before your lordship rises, my lord, I know I have missed the bus to mention, my lord. May I only mention one execution application for inclusion any day, my lord, lordship. Keep it, keep it.
So what is the predicament mentioning at the
My lord, I was
right
late, my lord. I was
city? Any now, any দিয়ে দিও at a suitable date.
grateful.
ঠিক আছে? চলো। নাও, আমাদের সম্পত্তি নিয়ে চলে যাও। Make it not to the lot. He's busy on the code number 28. Oh, grateful. Please come. Please come.
My lord, he has left the court. That is what I called him up and he said that I've already left the court. That is, I just told him.
And your
that-
lordship also requested, he also said that Monday, your lordship requested, no, we need this week because next week maybe division bench. One point also, only raised by your lordship that post-mortem report not proof, doctor not come in spite of the repeated persuasions. 304. Only this point, otherwise Mr. Panda also argued.
That is what.
Yesterday also I came before your lordship mentioned at the time of Rahil. When your lordship desired to pick up this matter on yesterday also.
I just told him that I don't know why. He was under the impression maybe 3:30 the matters won't be called. He should have waited. Original side matters.
Your lordship also stated that after completion the original side matter will take up. But difficulty is
There is
some
indication to that effect in every Friday. I check.
some
File
advocate
done in.
coming from the district court, usually Friday left to the court and for attending the chamber on Sunday or Saturday.
Take down. I don't have any division bench. I shall be in single bench.
Oh,
So
then
details can show.
original side matter also not there.
Huh?
Monday only
Thursday and Friday.
Thursday, Friday. So it will be taken up at 2 p.m.
He's asking whether original side matters